Hi, I'm Bobby Cloud, and I'd like to talk to you about blood and urine evidence. If during the course of your DUI, you chose to either take blood or urine samples as the evidence that they're going to use against you to prosecute you in your DUI, there's some important things that you need to know. There are two types of tests. Blood and urine are treated differently in the chemical testing that is done, but both have to be sent to a facility for that information to be obtained from analysis of the information. An important thing to know is that both types of tests can be contaminated depending on if there's other agents included inside of the samples. Furthermore, it can be contaminated during the collection process. It's important to look at that information and get the proper documentation from the prosecuting agencies such as the Sheriff's Department or the Police Department, and make sure that there's no errors in the processing of your samples. In addition to that, there are strict regulations and laws associated with the transfer of evidence from one facility to another facility. There's a sign-in and sign-out sheet that's required by every person that touches your evidence. That needs to be reviewed by a competent attorney to ensure that there's been no break in the chain of evidence. If there is a break in that chain of evidence, you can file a suppression motion. If you're successful in that motion, you cut off the prosecution of your DUI before you ever get to trial. As you can see, this is an important step in the defense of your case. I highly suggest that you talk about these issues with a competent attorney to see if your case could be dismissed.